Start. Leave granted. This appeal has been filed by the appellant against the impugned judgment and order dated 1/12/2010 of the High Court of Judicature of Bombay in Charu Kishore Mehta versus Charity Commercial, whereby the High Court dismissed the LPA filed by the appellant and upheld the judgment and order dated 2/3/2010 passed by the learned single judge of the High Court for the purpose of considering the rival legal contentions urged on behalf of the parties in this appeal, and with a view to find out whether this court is required to interfere with the impugned judgment and order of the High Court. The necessary facts are briefly stated hereunder. The appellant herein is the permanent trustee of the Leelavati Kirti Lal Mehta Medical Trust (for short the trust), which is a public registered trust in accordance with the terms of the registered trust deed and is governed under the provisions of the Bombay Public Trusts Act 1915 (for short the Act). Full stop. Respondents 2 to 9 are the trustees of the aforesaid trust along with the now deceased Vijay Mehta, who was the managing trustee of the trust during the relevant period of time. Full stop. The case of the appellant is that respondents 2 to 9 have allegedly continuously neglected their duties and have committed malfeasance by acting in breach of trust with respect to the trust properties. Full stop. They have also misappropriated and improperly dealt with the properties of the trust from the year 2001 to 2006. Full stop. It has been further alleged by the appellant that they have also squandered the trust money to the tune of crores of rupees and have committed serious acts of malfeasance. The appellant, on coming to know of this fact in the year 2006, filed an application, being application number 17 of 2006 under section 41D of the Act before the Joint Charity Commissioner (for short JCC), making various allegations against the aforesaid respondents 2 to 9, including the deceased Vijay Mehta, and alleged that they are liable for dismissal from their trusteeship of the trust for their acts of nonfeasance and malfeasance. Inter alia, contending that they have abdicated their functions and duties as provided under the provision of section 36A of the Act after their acceptance as trustees in the said trust as provided under sections 46 and 47 of the Indian Trusts Act 1882, which is applicable to the fact situation of the present case. Full stop. On the basis of the said application, JCC framed 8 grave and serious charges jointly against respondents 2 to 9 (original respondents 1 to 8) and the deceased Vijay Mehta the original respondent 9. Full stop. JCC wide its order dated 25/9/2009 after affording opportunity to the parties in the present case, recorded its findings on the charges and held that the charges against respondents 2 to 9 except charge 4, which was against the deceased Vijay Mehta, have been proved. Full stop. JCC, however, dismissed the application against respondents 2 to 9 and exonerated them by holding that they are only negligent in putting blind faith in delegating their powers and duties to be performed as trustees of the trust in favor of the deceased Vijay Mehta, the managing trustee of the trust, full stop. Therefore, the application against them was dismissed by him, full stop. The appellant herein being aggrieved by the said findings and reasons recorded by JCC filed writ petition number 9501 of 2009 before the learned single judge of the High Court, whereby the High Court vide its order dated 2/3/2010 dismissed the writ petition, full stop. Thereafter, the appellant filed LPA number 268 of 2010 before the High Court, which was also dismissed by the division bench on the basis of the findings recorded by the learned single judge, and held that the charges framed against respondents 2 to 9 by JCC were established. However, as there was no evidence against respondents 2 to 9 to hold them responsible for the transactions from the year 2001 to 2006, except on charge 4, it has held that there is culpability of the deceased Vijay Mehta, and further, JCC has held that the charges against respondents 2 to 9 in delegating their powers and functions to the deceased Vijay Mehta as per clause 9 and 11 in bracket H of the trust deed vide the resolution of the trust dated 30.8.2001 stood established and proved against them, but they cannot be held guilty for the same, as the appellant herself was a signatory to the above resolution. The division bench of the High Court vide order dated 1/12/2010 declined to interfere with the order dated 2/3/2010 passed by the learned single judge, and found that the same is justified after considering that the appellant herself was a party to the above mentioned resolution that had appointed the deceased Vijay Mehta as the managing trustee of the trust, full stop. Further, no steps were taken for the cancellation of the resolution by her, as she did not even enter into the witness box before JCC to justify her conduct that she is not a signatory to the resolution wherein the deceased Vijay Mehta was appointed as the managing trustee by other trustees who are respondents 2 to 9 in the present appeal, full stop. Further, the High Court held that the appellant did not object to his functioning as a managing trustee at the same time when all the powers were being delegated to him, and found that the petition was not seriously contested before the learned single judge and rejected the appeal of the appellant, full stop, para. Aggrieved by the said judgment and order of the division bench of the High Court, the present appeal is filed by the appellant with a prayer to set aside the judgments and orders of JCC and the High Court by quashing the same, and requested to pass such orders as this court may deem fit and proper in the facts and circumstances of the case, by urging various facts and legal contentions, full stop. Para. Mr. V. Giri, the learned senior counsel on behalf of the appellant has contended that the appellant was not present in any of the meetings during the relevant period, that is 30.3.2002 and 1.4.2007, and in particular the meetings held on 30.8.2001 and 19.7.2002, which fact has been deposed by Mr. Kishore K. Mehta in bracket the original respondent 10 before JCC, the husband of the appellant in the proceedings before JCC, full stop, over.